Hi, and welcome to the first module of 6, Training for High Fidelity Wraparound Providers Working in Wyoming's Juvenile Courts. This is Module 1, which is an overview of juvenile court. We wanted to start with some disclaimers. The first one is that this presentation provides information as outlined in Title 14 of the Wyoming statutes, but is not intended to be exhaustive. It's to provide general information about juvenile court. So if you need more detailed information, please refer to the Wyoming statutes. Also, the information contained in this PowerPoint and this training may not represent juvenile court practice in your community. Many things can affect practice at a local level, including the immediate availability of judges, parents, attorneys, or guardian ad litems, specialization of a county or district attorney, the availability of service providers, or type of service or community programs, preferences, local customs for MDT coordinators, and a million other things. So please take the time to familiarize yourself with the jurisdiction that you work within. Information on which judicial districts include which counties can be found at the web address listed on this slide. We're going to start with how a juvenile case begins. There are only 3 ways for a child to enter the juvenile court system. First is protective custody can be taken. This is usually occurring in abuse neglect cases or child in need of supervision cases, which you'll also hear referred to as CHINS proceedings. The second way is the filing of a petition and summons into court. This can happen in all 3 types of cases in juvenile court: abuse neglect, CHINS, and delinquency cases. This just means that the case begins with the filing of that document in the court, not with protective custody or an arrest. The third way is arrest or detention. This is most often happening in delinquency cases, but occasionally this can happen in a CHINS case as well. Please note that ultimately a petition is filed in all juvenile cases, even if the case begins with protective custody and the removal of the child from the home or an arrest. Abuse and neglect, CHINS, and delinquency cases will be discussed in further detail in subsequent modules. Right now we're going to do an overview of the juvenile court process. It's a shortened at-a-glance review of the similar hearings and steps that occur in all 3 types of cases in juvenile court. First, as we discussed, protective custody, an arrest, or a petition is filed that'll begin the juvenile court process. If the child is taken into protective custody or an arrest is made, then the first hearing in court will be the shelter care hearing or detention hearing. If an arrest or temporary protective custody is not taken, then the first hearing that you'll likely see in juvenile court is what's called an initial hearing. The shelter care hearing and the initial hearing can also be held together, which we'll talk about in subsequent modules. The next hearing is an adjudicatory hearing, also known this is the trial. You can also at this point have a consent decree that you likely will not have an adjudicatory hearing if there is a consent decree in place. The next hearing is the dispositional hearing. This can be held along with the adjudicatory hearing if the judges and the players would like. Most often it's held separately. Next is a review hearing. These are held every 6 months. And then after that is a permanency hearing, which is held every 12 months. There are also 4 types of cases that can arise out of a juvenile court case. You can have an appeal to the Supreme Court. You can have a termination of parental rights case. You can have a guardianship case and can also have an adoption case. These 4 cases are likely in different courts, not in juvenile court. Sometimes they have a different judge. They may have different attorneys, and they have different rules and procedures to follow. So please note, in these 6 modules, we are really only talking about the three types of cases in a juvenile court hearing: abuse, neglect, chins, and delinquency. We're not talking about appeals, TPRs, guardianships, or adoptions. The first thing you'll notice in juvenile court is there are a multitude of players. This slide gives you an idea of how many can be involved. Not all are listed, but obviously there will be a judge involved. There will be a district or county attorney. There'll be people involved from the Department of Family Services, at least one. You'll have a caseworker. Sometimes you may also have the intake worker or the investigating worker. You'll have a multidisciplinary team, which we'll talk about in subsequent modules. Obviously, the parents are involved in juvenile court. You'll have a guardian ad litem for the child. Sometimes a CASA, a court-appointed special advocate, which we'll talk about. The Attorney General's office may be involved. The children obviously involved. Each of the parents may have their own parent attorney, which is why this is multiple. There's schools, therapists, counselors, high-fidelity wraparound providers, and a multitude of other service providers involved with these families. We're going to walk through the main players in juvenile court and talk about who they are and what their roles are next. The first is the district attorney. This can also be called the county attorney. So in Cheyenne and Casper, the district attorneys are the prosecutors in juvenile court matters. In all other counties, it is the county attorney. These attorneys represent the state's interests. They don't represent the Department of Family Services. In many counties, this attorney wears other hats. So not many counties can support a full-time district or county attorney just prosecuting juvenile court cases. So they may only have a certain number of juvenile court cases and also have criminal cases on their docket. They decide whether to bring or dismiss a case. They present the state's interests in court and file the legal documents that are relevant to the case. You may also hear them called the prosecutor. DFS is actually represented by the Attorney General's office, not the district attorney. And so sometimes you'll see the Attorney General's office in court with DFS. They may also represent the county in civil matters. They may or may not be a full-time expert in juvenile proceedings. Next is the guardian ad litem. This is an attorney that's appointed by the court to represent the child's wishes and best interests. They are supervised and trained by the GAL division at the Office of the Public Defender. There's a mandatory appointment for them in abuse and neglect proceedings and discretionary appointment in chins and delinquency proceedings. What this means is that you will always see a GAL in abuse and neglect cases, and you may or may not see them in chins and delinquencies. Their client is the child. Sometimes people think it's the judge, but it's the child. They are paid for by the county and the state. They're supervised, again, by the GAL division, and they conduct independent investigations and ensure that the child's wishes and best interests are met by the case. Next is court-appointed special advocates. These are volunteers that are assigned by the CASA program if the court orders their involvement. Right now, they are in 7 counties in Wyoming and not in the others. So you may or may not see CASAs depending on which county you live in. They also are not on every single case in some counties, and in others, they are in every single case. They must be trained and screened in accordance with national standards. They serve at the pleasure of the court, and they must be sworn in by the court before they begin their service. They serve the best interests of the child, and only in abuse and neglect cases. Their role is separate from the GAL, but the court rules do indicate that the GAL and the CASA are expected to collaborate and cooperate. Next are the parents and guardians of the children. These parents must be present at court hearings. If they don't show, they can actually be held in contempt of court, and the court may also issue a bench warrant for them to appear. The court has jurisdiction over those parents that can require them to do certain things in the case, such as participate in a case plan, attend parenting classes, etc. If the child is in out-of-home placement, you'll likely be working with a foster or relative caregiver. Foster and relative caregivers are not parties to the proceedings, but they do have right to receive notice of hearings and an opportunity to be heard at those hearings. The district or county attorney has to provide that written notice to them. And again, if they attend and want to speak, the court can give them that chance to be heard. The Department of Family Services will be involved in every case in juvenile court. They have a multitude of roles. The first is to receive, assess, and investigate any report of abuse or neglect within 24 hours. They also are going to communicate and coordinate and potentially provide services for the family. They're going to be doing case planning with the family and the child, making recommendations to the court regarding services, visitation, permanency. And then you will also sometimes see a DFS probation officer that will be supervising youth in CHINS and delinquency cases. Next, you have high-fidelity wraparound providers. They may be appointed by the court as a member of the MDT, or they may operate completely outside of the court process. There's some important things to understand as a high-fidelity wraparound provider working in juvenile court. First is understanding of what non-negotiable items are coming out of court orders that need to be presented to the wraparound team. Also that new information that's learned at the MDT cannot be shared with the wraparound team as it's confidential, and this will be addressed in more detail in subsequent modules. That there may be a release of information needed. And also that the meeting types, there's quite a few different meeting types that are similar. There's a multidisciplinary team meeting, which again is going to happen in the juvenile courts and comprised of the required members and optional members. The court may also appoint those providers from the high-fidelity wraparound team or their care coordinators to the MDT. The purpose of including that high-fidelity wraparound provider on the MDT team is to educate the MDT on the specifics of the high-fidelity wraparound plan and to ensure that the non-negotiables from the court are included in the high-fidelity wraparound plan. The purpose is not so that the care coordinator can keep up to date on information in the court that's confidential. The MDT meeting is comprised of parents, someone from the child's school, DFS, the child's counselor or mental health professional, the district or county attorney, the child's attorney or GAL, the CASA, and the foster parent. The team may also include the child, a relative, or other professionals involved with the family if the court orders. Sometimes the family is also involved in family partnership meetings. These are a process to help reestablish natural support systems for dealing with current problems. They're comprised of support people that the family identifies, as well as DFS agency representatives who are involved with the family and others. The idea of the partnership is to provide a forum for the family to creatively develop strategies that incorporate their natural supports with assistance from the systems in which they're involved. These family partnership meetings could be held before MDTs or at the same time, and could also be combined with high-fidelity wraparound team meetings. The court is not bound by any decisions made by this family partnership meeting. High-fidelity wraparound meetings, as you know, are occurring outside of juvenile court. There can also be family team conferencing, which is a gathering of family members, friends, and members of the family's faith community and professionals who join together to jointly develop individualized plans to strengthen the family's capacity, to assure safety for the child, and stability and permanency. And then there's also just separate facilitated meetings by the Department of Family Services. All of these meetings occurring, the court is only bound to consider the recommendations of the MDT meeting. So There's definitely a place for high-fidelity wraparound providers and the juvenile court to coexist, but there are some statutory constraints around this. The first one is confidentiality, what MDT members can't share with non-MDT members, even if they're part of the child and family team in the high-fidelity wraparound. Also, high-fidelity wraparound and CME staff and providers cannot attend court proceedings or MDTs unless they are appointed to the multidisciplinary team, and then again, they're still not going to be at court. However, in limited circumstances, a provider of a specific service may be able to attend a specific proceeding for the purpose of providing testimony on an issue in dispute, but that would only occur if an attorney subpoenas them and asks them to provide that testimony. And again, the high-fidelity wraparound provider may be made a member of the MDT, but only via a court order. So as a high-fidelity wraparound provider, if the child and family that you're working with is in juvenile court, just note that you don't automatically attend the court hearing or the MDT. The other constraint is that the child and family must follow court orders and DFS case plans regardless of what is in the high-fidelity wraparound plan or decided by the family or high-fidelity wraparound team. The risk here is a probation violation or contempt charges. If the plan coincides, the family is following one direction, so it's very important that the high-fidelity wraparound plan contain the non-negotiables from juvenile court. Discussions of how the CME can assist these clients as they discharge out of the juvenile court is going to be really important. So there are court rules for juvenile court. Here's where you can find them, where the Juvenile Justice Act is, information about juvenile probation, and then the rules of procedure for juvenile court and the rules governing teen courts. A special note about concurrent criminal and juvenile proceedings. Sometimes an act of abuse or neglect will end up both in the juvenile court and also in the criminal court for criminal charges. These are separate and different proceedings. Proceedings in juvenile court cannot be delayed or stayed waiting for the criminal proceeding to end in district or circuit court. All proceedings in juvenile court have to be pursued pursuant to the timeline set forth in Title 14 of the Wyoming statutes. Also, please note that criminal proceedings are not closed and confidential like juvenile court proceedings. So you can actually go to court and listen to those criminal proceedings if you wish. Thank you for listening to Module 1 of the High Fidelity Wraparound Training for Juvenile Court. There's 5 other modules in this training if you wish to listen to those as well.